Responding to a credit card debt lawsuit. Being represented in court by a lawyer typically results in a better outcome. So first, try to obtain legal assistance. Your local county bar association can refer you to an attorney who handles your type of matter. If you cannot afford an attorney, contact your local legal services organization to see if you are eligible for free advice or representation. Avoiding repercussions. Ignoring a credit card debt lawsuit can lead to serious financial repercussions. Once you are served with a complaint, you have 35 days to file an answer. If you don't file an answer, you will be in default. After the case goes into default, the creditor will obtain an award of money called default judgment. Judgments are valid for 20 years. A judgment allows the creditor to do the following: garnish your wages, levy your bank account, put a lien against your home and other property. Filing an answer. You can avoid default judgment by filing an answer to the lawsuit. Filing an answer can be relatively simple, and self-help forms are available at the NJ Court's website. You can file the answer and other documents online through the Judiciary Electronic Document Submission. Please look for these links below. Defenses to raise. 1. Unauthorized charges. You are not liable for unauthorized charges. For example, identity theft, data breaches, lost or stolen cards. 2. Disputed charges. If you did not receive an item you purchased or the goods were defective and you disputed the charges. 3. Statute of limitations. Depending on the type of debt, the creditor will generally have 4 to 6 years to sue you after you fail to pay. 4. Debt buyer defenses. If you are being sued by a debt buyer and not the original creditor, the debt buyer must A. have a consumer lending license, and B. show the complete chain of the title of the purchased debt. 5. Bankruptcy. If you filed for bankruptcy, the debt may have been discharged. Know your options. You can always resolve the debt by negotiating a settlement. But first, ask yourself, is it in my interest to pay this particular credit card debt? If you have other debts, you may want to either pay off other debts first or file for bankruptcy. For example, student loan, tax debt, and child support are generally not eliminated by bankruptcy, so you may want to tackle those obligations first. You also may want to prioritize your rent, mortgage, or utility bills if you are having trouble paying your basic living expenses. Or, if you have a lot of debt and you have income or assets you want to protect, you should consider filing for bankruptcy. Bankruptcy will eliminate or discharge most kinds of debt, including credit card and medical debt. Negotiating with debt collectors. Even if you owe the full amount and don't have a defense, you can still negotiate with debt collectors. If you are able to pay a good portion of the debt, try offering a lower lump sum as a final settlement. Many debt collectors prefer a lump sum that is less than the full amount as a final settlement, rather than waiting for the full amount over time. If you can't afford a lump sum, you should still try offering less than the full amount over a short period of time, perhaps a period of 2 to 4 months. Even if the debt collector will not take less than the full amount, you can almost always negotiate a payment plan based on what you can afford, even a payment plan over a period of years. You settled your case. Now what? 1. Get the settlement agreement in writing before making any payments. 2. Keep a record of your payments. 3. Consider paying by money order so they don't obtain your bank account information. 4. When the debt is paid, make sure the debt collector sends you a letter confirming that the debt has been paid. 5. Insist that the debt collector provide you with stipulation of dismissal with prejudice to file with the court. 6. If a judgment was entered against you, ask for a warrant to satisfy judgment once it is paid off. For more information and/or legal assistance, please contact Central Jersey Legal Services.